the matter of Green Trees Apartments versus Moni Dickerson, 2502122. And counsel, your appearance, please.
Christopher Borkin, P86265 for the plaintiff.
So, Mr. Rick.
Is that coming from your audio, counsel?
It is, Your Honor. I'm in court in the hallway.
Okay. Ms. Dickerson, if you could please place your name on the record.
Moni Dickerson.
All right, thank you. And today's date scheduled for the second hearing in this matter. Counsel?
Your Honor, we reached an agreement. We would ask the court to enter a judgment by consent. We've agreed the total balance is as follows: $4,358 in rent, $180 in court costs, totaling $4,538. I'm sorry, Your Honor, that's not correct. Yes, that is 4,538. That is the total. Moni Dickerson will pay that honor before January 30th. She's given me permission to sign the consent judgment on her behalf. I texted her a proposed copy of the consent judgment, and I did explain her rights under MCR 4.201J.
Okay, and Ms. Dickerson, you heard the terms of that judgment, correct?
Yes, I did.
Okay, and you understand that Mr. Borkin represents the interest of your landlord and not your interest, correct?
Yes, I do.
And you've also received your advice of rights in your packet of information, correct?
Is that like a separate document that I should have received?
Yes, it would have been in your packet of information. You would have received a whole lot of information. One of which would have been your advice of rights.
Yes, I received that.
Okay, and you had an opportunity to look at that, correct?
Yes.
Okay. And you understand, do you have any questions regarding that?
No, I do not.
Okay. And you also understand, ma'am, your rights under the court rule as explained to you by Mr. Borkin, correct?
Yes, I do.
Okay, and counsel, you said $4,738? You're muted, sir. You're muted, counsel.
Excuse me. Total was 4,538 or
4538. Okay. I wrote it down on my other screen, but I'm doing the judgment as we speak here. And what was the rent, the unpaid rent, and then the cost, counsel? If you could separate those out again, please.
Rent is 4358. Court costs are 180, Your Honor, totaling 4538.
Hold on, counsel. Hold on, please. We're trying this new thing where we're doing the judgment as you're on the date of the hearing. So I'm having to figure out where to put this stuff. So 4,300. Mr. Borkin?
Sorry about that, Your Honor. Rent is $4,358. Court costs are 180.
Hey, hold on, counsel. I need you to slow down. 400 or 4,300 what?
58.
$58. All right. Because I'm typing it on the judgment. And so I'm trying to, there's different buttons I have to hit before I can do it, before I can type anything. So I'm not able to go as quickly on this judgment section as I am on the other section.
Understood.
And how much were court costs?
180, Your Honor.
Okay. All right. And so, ma'am, you also understand that your rights under the court rule is explained to you by Mr. Borkin, correct?
Yes, I understand.
Okay, do you have any questions, ma'am?
No, I do not.
The court does find the waiver of rights is valid. The terms of the judgment are reasonable, and the court does find by consent that plaintiff is entitled to recover possession of the property. The amount now due and owing for unpaid rent and other costs is $4,538. If that amount is not paid or defendants not move out on or before January 30th, plaintiff may apply for an order evicting the defendant. Additional money may be owed if damage to property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant. No money judgment will enter at this time, and the court has signed the judgment. I will indicate if you're both comfortable with that on ma'am, on your signature line, I can put via Zoom. Are you comfortable with that?
Yes, I am.
That works for
Okay.
plaintiff as well, Your Honor. And unless it's
you're-
already signed.
It's signed by Attorney Katz.
Great, thank you.
All right, so that's what we're trying to do. We're trying to do the judgments as they're as everyone's agreed to it, and then you don't have to worry about signing it or sending it in after. So, okay, I'm hoping that that's all saved appropriately and okay, good luck to you.
Thank you, Your Honor.
Thank you.
Epic Property Management versus Wendy Correa, 2502-228. Counsel, your appearance, please.
Good morning again, Your Honor. Jen Wilburn, P 83143 for plaintiff.
Okay, and Ms. Correa, your name for the record, please.
Wendy Correa.
All right, and counsel, you had an opportunity to speak to Ms. Correa in a breakout room, correct? You're muted, Ms. Wilburn.
Sorry about that, Judge. That is correct. There's no dispute as to the amount owed. Ms. Correa has indicated she's applied for rental assistance. I did advise proof would need to be provided to the court within 5 days via the DC 539 form.
Okay, and ma'am, when did you file for rental assistance?
Department of Health and Human Services.
No, when did you do that?
So they won't help me until I get something from after going to court. So I have to do it today.
Okay, well, actually, they're incorrect in that, quite frankly. I know they won't tell you that, but they only need a summons and a complaint. They don't need a judgment or otherwise. However, the court will adjourn this for 14 days. You have 5 days to submit that form, ma'am, DC 539.
Is it D like dog?
D is, yes, D like DC, District Court, Form 539. And then counsel, we can put this to, looks like January 27th.
That works, Judge. What time?
Let's do 9 a.m.
So I have a question. January 27th, I just started a new job and I'm supposed to be in Southfield for orientation at 7:30 in the morning. Can we do a different day?
We could do Friday, January 30th at 8:30
Okay.
a.m.
Okay.
Does that work for you, counsel?
January 30th at 8:30?
Yes.
That works.
Okay. Does it show we have a jury trial that day? Oh, okay. We have to double check the jury trial. Things after the in chambers we've had to see if some of those are still going. Okay, we'll see you all back January 30th at 8:30 a.m.
Thank
Thank you,
you.
Judge.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
All right, thank you. Mr. Nee, your name for the record, please.
Benjamin Me.
Okay. Today is the date scheduled for sentencing in this matter on your client's plea to disorderly conduct. Malicious destruction of property, trees, shrubs, etc. was dismissed, and so was the trespassing. And so, counsel, if you could please, has there been any modifications or corrections that need to be made
No, Your Honor.
to the report?
We reviewed the PSI. It is factually accurate.
All right, and what would you like me to know, counsel?
Judge, I saw the recommendations. I believe that they are extremely fair. I believe that it puts my client in a position to not fall into the nature of recidivism. Judge, I saw there was a 1 month recommendation to stay away from the complaining witness. I'd ask that it be adopted. Thank you, Judge.
So if I recall correctly, sir, you were frustrated because you were, if I recall correctly, getting the runaround from management at your apartment, correct?
That's correct.
Okay. And while I understand that the manager indicates that the named victim was no longer employed by the apartment complex, and they had an opinion that you shouldn't have been charged at the end because, you know, perhaps there was some fault on behalf of the management company that your frustrations were valid. Your behavior in response to those frustrations, sir, is not okay
I understand.
at all. And so, sir, you are on, you work part-time, correct?
Yes, ma'am.
Okay. And so why don't you work full-time?
I have had a rough time finding a job since being unlawfully discharged from Ford in May.
Okay, I see the recommendation. Well, first, the court's going to note that as to that after hearing from counsel, reviewing the report, the recommendation, hearing from Mr. Me, the court does find there's reasonable grounds to depart from MCL 769 in addition to the circumstances surrounding or the facts of this matter. The court also finds the following sentence to be in the best interests of justice, to be reasonable, proportionate to the seriousness of the matter, taken into account the circumstances surrounding Mr. Me and the legislative guidelines. I understand that the recommendation is 1 month. However, I believe this court believes that Mr. Me needs some assistance in learning how to properly manage his frustration and his emotions when he is in an upsetting situation. Therefore, the court's going to order 6 months probation. You're eligible, sir, for early discharge. I'll go over that in just a short bit. You're not to have any contact with Miss Long. And you are also not to, or you're to participate in an anger management class. The rehabilitative goal for that condition, sir, so you can learn how to properly respond to upsetting situations, which there are plenty of in life, that is for sure. And hopefully this matter doesn't occur again. And the court's going to also order or indicate that you are eligible under 771.1. Any questions regarding those conditions?
No, Your Honor.
The court's going to order a $300 fine, $100 screening assessment fee, $300 supervision oversight fee. That's $50 a month at 6 months. Since you're eligible for early discharge, up to half of that could be waived. $300 the cost of prosecution and crime victim assessment fee of $75. Justice system assessment fee of $50 for a total of $1,125. You can set up a payment plan with probation, sir, and as I did indicate, you're eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. Some money's going to be painful, or you made a good faith effort toward making full payment. Do you
Okay.
understand all of that, sir?
Yes, Your Honor.
Okay. All right. Please email into probation by 10:30. Okay.
Thank you.
All right. Thank you. Let's go off the record for a moment.